that report. So I want to thank you all for coming today. There has obviously been a lot of anticipation about this investigation, this report, a lot of press, and we wanted to ensure that its publication was communicated properly. Given the many inaccuracies that have been reported about this issue over the last several years, we wanted to take the opportunity to personally share the report, and we urge everyone to read it in its entirety rather than just headlines and talking points. The report is published on the Orange County Grand Jury website and should be going live as we speak, and hopefully any media agencies here will include a link to the original report in their printed articles today. As the foreperson of the 2016-17 Orange County Grand Jury, I would now like to read a statement. It's going to be a long one. The Orange County Grand Jury is charged with investigating civil issues within Orange County government, and as such, an investigation of specific criminal activities and specific civil rights violations are outside its charge. However, it is within the jurisdiction of the civil grand jury to investigate the operations of county and city government, including the Orange County District Attorney's Office and the Orange County Sheriff's Department and other local law enforcement agencies. Allegations have been made that these entities have standard practices wherein they routinely violate defendants' rights in their quest to win. It is therefore appropriate that the Orange County Grand Jury investigate these allegations. The Orange County Grand Jury began its investigation by reviewing more than 2,000 pages of initial court documents related to the People v. DeCry and the People v. Wozniak cases, where allegations of the existence and use of jailhouse informants in Orange County were first brought to light. In addition, the Orange County Grand Jury reviewed articles in the Orange County Register, the Voice of OC, the New York Times, the OC Weekly, and the Intercept, read more than 60 press releases from the Sheriff's Department and the District Attorney's offices, reviewed the 1990 Los Angeles County Grand Jury report, and watched videos of town hall meetings and interviews with the DA and the Sheriff. Additionally, the Orange County Grand Jury studied the 2016 Informant Policies and Practices Evaluation Committee report, known as the IPEC report, the 2002-2003 Orange County Grand Jury Investigative Report of the OCDA's office, the 2006 California Commission on the Fair Administration of Justice report, and the 2007 and 2015 internal audits of the Orange County District Attorney's office. The Orange County Grand Jury subpoenaed more than 8,000 pages of documents from the Orange County District Attorney and obtained more than 3,000 pages of documents from the Orange County Sheriff's Department. The grand jury interviewed more than 150 individuals, including active and retired deputy district attorneys, senior deputy district attorneys, assistant district attorneys, investigators, and executive staff. Interviews were conducted with dozens of Orange County Sheriff Department personnel, including special handling deputies, classification deputies, training deputies, retired deputies, members of the new custody intelligence unit, and current and retired command staff. The Orange County Grand Jury also interviewed nationally recognized legal scholars, Orange County public defenders, private criminal defense lawyers, local law enforcement detectives and commanders, judges, members of the Board of Supervisors, as well as authors of various reports and audits to gain additional insight on previous recommendations, the current and legal use of jailhouse informants, and application of relevant case law. The Orange County Grand Jury was given access to the Orange County Informant Index in the DA's office, as well as the inmate classification records, aka TRED, used by deputies in the Orange County jails to ascertain what information is stored and available in the databases of these two offices regarding jailhouse informants. The Orange County Grand Jury toured the Intake Release Center of the OC jail system multiple times to better understand operations and housing moves of inmates, as well as geographical understanding of Modules L and Module J, referred to in press accounts as the snitch tank. The grand jury attended hearings in both the DeCry and Wozniak cases and attended multiple training sessions for prosecutors, investigators, and sheriff's deputies. Inquiries were made of neighboring district attorney and sheriff's departments about the policies used regarding jailhouse informants to better understand alternative methods of classifying inmates and tracking jailhouse informant activity. We reviewed Orange County cases where illegal informant use had been alleged in an attempt to verify the allegations of systemic prosecutorial misconduct. Members of the grand jury read extensive law review articles to better understand the constitutional legal issues under discussion. In all, the Orange County Grand Jury spent more than 3,500 man-hours, read more than 40,000 pages of documents, listened to dozens of hours of taped recordings, and interviewed more than 150 people in its investigation of the criminal justice system in Orange County. All the facts contained in the report had a minimum of 3 corroborating pieces of evidence, and the grand jury believes this investigation has been thorough and comprehensive in its attempt to speak with all sides of the criminal justice system. This investigation was conducted independently from all other grand jury investigations and other government entity investigations into the District Attorney and Sheriff's Department. We would like to note that both the Orange County District Attorney's Office and the Orange County Sheriff Department command staff were cooperative and transparent with the Orange County Grand Jury throughout this investigation. All right. The word informant has been used extensively in court motions and press articles, but has different meanings. In the general vernacular, an informant is someone who informs. However, within the context of jail communities, the term has fundamentally different meanings. The myriad definitions and nuances of what constitutes an informant have caused confusion and may have contributed to the current controversy and unnecessary erosion of trust. The report seeks to clarify this confusion. Mercenary informants, commonly referred to as snitches, are a very specific type of informant that has been widely reported to exist en masse in the Orange County jails. The Orange County Grand Jury was unable to identify any of this type of informant currently housed in any Orange County jail, and we are confident that requests for this type of informant activity are few and far between. This is not to say that the Orange County Sheriff Department or local law enforcement agencies are not using or have not used jailhouse informants. However, this use is almost always organic in nature, narrowly focused, and primarily to ensure the safety and security of the jails and not to investigate crimes. The existence of informants in the Orange County jails does not constitute a program. In fact, the Orange County Grand Jury found no structured jailhouse informant program operating in the Orange County jails. While the trial court in Decry has stated that the question of the existence of a jailhouse informant program has left the station, the Orange County Grand Jury disagrees. The mere existence of informants in the jail is not conclusively indicative of a program. The Orange County Grand Jury found no direct material evidence of an organized, recognized program of jailhouse informants. A program requires certain elements to be in place. The grand jury did not find a strategic plan or schedule for jailhouse informants. The grand jury found no formal training, no dedicated budget, no codified job descriptions, no calendaring of events, no advanced scheduling of activities, nor any approved recruitment material for Orange County Sheriff Department personnel for a jailhouse informant program. There are no formal discussions with inmates during or after booking to place inmates into an organized, structured jailhouse informant program, such as those that exist for mental health, language classes, or legal assistance, other programs in the jails. No outside agency supplies dedicated personnel or resources supporting jailhouse informants, running jailhouse informants, supervising jailhouse informants, or supplying jailhouse informants as seen in other program offerings within the jail communities. In short, the Orange County Sheriff Department does not have a stable of informants that they routinely disperse throughout the jail to gather evidence on crimes, either legally or illegally. The Orange County Grand Jury found no direct evidence of a conspiracy to place an informant near Decry prior to his first conversation with a jailhouse informant. All the evidence and testimony the grand jury reviewed points squarely to a coincidental placement of Decry next to a prolific informant who personally saw an opportunity to expand his portfolio with law enforcement and provide evidence on a high-profile inmate. A handful of special handling deputies drifted from their custodial duties over a period of years into investigating crimes. The lack of proper supervision and appropriate policies allowed this to continue longer than it should have. This drift does not constitute an Orange County Sheriff Department jailhouse informant program, but rather the work of a few rogue deputies who got carried away with efforts to be crime fighters. The negative effect was enhanced by inadequate supervision of these activities, as well as the deputies' unawareness of consequences of their actions and a lack of knowledge for the scope and breadth of their discovery obligations as part of the prosecutorial team. After extensive documentation review and interviews, the Orange County Grand Jury has concluded that the TREAD system is not only similar to systems used throughout all jails in California, but is a necessary system to record the movement and classification of all inmates for the protection of the inmates, the facility, and Orange County Sheriff Department personnel. TRED was never designed to be, and is not, a repository of information about an inmate's informant activity. After review, the grand jury concluded that the Special Handling Deputy's log, of which we received the complete unredacted copy, was primarily a shift record initiated by special handling deputies to document daily events and occurrences in order to facilitate the exchange of information during shift changes. There is no doubt that comments in this log were often juvenile, ethnically insensitive, and embarrassing to the Orange County Sheriff's Department. However, it was not created as a repository of information on informants and their testimony or the purported movement of informants within the facility. The value add from the discovery of this log to the defense case for misconduct has been greatly exaggerated. The contents of this log shed little light on Decry or Wozniak's movements while in custody. It would seem that it was the failure to disclose the log rather than the actual contents that created much of the angst around the Special Handling Deputy log. The Orange County Grand Jury found that the architects of most of the informant use in the Orange County jails is not the Orange County Sheriff Department personnel, but other local law enforcement agencies. These agencies are and continue to be a weak link on the prosecution team. This can set a challenging obligation for prosecutors who bear the affirmative burden for ensuring justice is done. In order for discovery to be properly gathered and provided to the defense in the statutorily required manner, it is essential that local law enforcement agencies understand their obligations to share information about informants and informant operations with the Orange County District Attorney's Office. The grand jury found that there have been discovery violations on the part of prosecutors in a small number of cases over a period of years due to a number of factors that are indicative of what happens to all organizations that are not diligent in maintaining awareness of their core mission. Allegations of a corrupt district attorney's office conspiring with the sheriff's department to violate citizens' constitutional rights are unfounded. Disparate facts have been woven together, and a combination of conjecture and random events have been juxtaposed to create a tenuous narrative insinuating nefarious intent. That narrative does not stand up to factual validation. The Orange County Grand Jury found no concerted effort by personnel in either the DA or the Sheriff's Department offices to circumvent the law in order to ensure successful prosecutions. The vast majority of prosecutors we spoke with are ethical, hardworking individuals who have not and will not file a case if they do not believe in the guilt of the accused. In an office where more than 15,000 felony cases are filed annually and nearly 97% are settled before they get to trial, allegations of widespread jailhouse informant use for trial purposes are not factually supported. The current search to get to the bottom of potential discovery violations in the Decry case has devolved into a witch hunt for agency corruption, a search that after 5 years and more than 40,000 pages of court documents remains fruitless. The Orange County Grand Jury found no evidence to support claims of a systemic, widespread informant program, and reports of such have been exaggerated in the press. Both the Orange County District Attorney and the Orange County Sheriff Department allowed individuals to drift from the core organizational mission, and that laxness in supervision has had the unfortunate result of an erosion of trust in the Orange County criminal justice system. It is clear to the Orange County Grand Jury that had individuals charged with supervising prosecutors and sheriff deputies been more aware of how those individuals were conducting business, this entire episode could have been avoided. This does not represent a conspiracy between the Sheriff's Department and the District Attorney. Both agencies are now aware of this shortcoming and have implemented organizational changes to repair the damage and ensure future issues of this nature do not occur. While the Orange County Grand Jury has now finished its investigation, the California Attorney General and the United States Department of Justice have ongoing investigations. Any further investigation of potential widespread systemic institutional wrongdoing surrounding discovery or informant issues in Orange County would be far more appropriately addressed by these agencies and not by the trial court for the largest confessed mass murderer in Orange County history. I will now take questions with the caveat that grand jury investigations are confidential, so I'm really only allowed to speak to what's in the report and not much else, if anybody has any. Messiah, there's been a lot of press about Messiah, and I think we talk about it in the report. Messiah assures that you cannot speak with or put an agent with somebody who has been charged with a crime. You may put an informant or anybody else with a in custody person, as long as it's not to discuss the crime for which they have been charged with. So an uncharged crime is fair game.
Okay, so you said that in your investigation, in the Decry case, it was an accidental, coincidental,
The first contact.
The district attorney's office has already conceded a homicide violation, right? You understand that?
I do.
You also understand last June, the district attorney's office wrote a letter to Dan Wagner, the assistant district attorney, belying everything you just told us, that there was a huge problem, that there was an employment program, that it was active, and they were doing capers. How do you rationalize what you just told us with that letter from the district attorney's office?
You would have to talk to Dan Wagner about why he did what he did.
Coming to us and telling us that there's a myth here.
I'm coming to you and I'm telling you that the Orange County Grand Jury has spent a significant amount of time investigating the allegations, and we cannot find factual evidence to support the notion of a program in the Orange County jails.
The district attorney was wrong in Decry in that letter. Is that right?
I'm not going to speak to Dan Wagner's letter, no. Again, specific pieces of evidence are not something I'm allowed to speak with. Messiah is triggered at the moment of arraignment and charge.
Are you aware that the tread records do contain evidence of movement, of deputies moving informants next to government targets?
The tread records do record movement of inmates, but that's not their sole function, and there's a lot of other information in tread records that have nothing to do.
Are you aware that the tread records
And I did answer your question and said, yes, I am aware.
actually move informants next to targets?
Yes.
Meaning they were represented by lawyers.
Moving informants is not illegal. It's not a Messiah violation. The jail is charged. They move people every day, and that's their job. Yes, ma'am.
What kind of public corruption legal advice did the grand jury receive? Who was your expert on public corruption that helped guide you?
The Orange County Grand Jury has, and is served by county counsel. In this particular case, because we were looking at county agencies, we would have gone to the Attorney General. The Attorney General didn't have the bandwidth with everything else that's going on, so they hired us outside legal counsel. And that, I think, has been widely reported to be Andrea Orden, and then Stroomwasser Wucher was her backup firm.
Okay, but they're not public corruption experts. Who were your public corruption experts that guided you?
I'm not sure I understand your question. Those were the individuals who are our legal advisors. Tony?
What specific cases besides Wozniak and crimes did you look at to arrive at the conclusion that there were no violations?
We looked at the roughly 30 cases that were listed in the motions, the court motions in both Decry and Wozniak, where there was alleged informant activity.
Can you give me a couple?
Off the top of my head,
Does it report these names?
there's a couple that are named in the report, yes.
You talked about you used the phrase witch hunt. I'm sure you're aware there's an entire hearing.
We've been there every day, yes. We're very aware.
Expand on that, because there's a judge across the street who obviously doesn't.
Judge Goethals and the grand jury, of course, has no jurisdiction over the courts or anything like that. We have sat in that courtroom many, many hours and listened to the testimony that's been given. I do believe Judge Goethals thinks he's doing his job, and it's his court. He gets to decide what goes on in his court.
But you're saying there is no there.
We're saying we did not find any evidence of an informant program in the Orange County jails.
You said you found evidence of that, but at the same time you said there were rogue deputies who were trying to, I think your word would act like members of the prosecution came out of that.
We're not saying there are no informants. We're not saying they don't use informants. What we're saying is there is no proactive, organized, formal program to recruit informants and to let them loose in the jail to gather evidence against other people.
But could there have been a mini program, if you will, among these rogue deputies you're talking about to try to facilitate and help out the prosecution?
I believe what the report says is there was a practice of using informants, but we'll stand by the fact it was not a program.
When you say that there were rogue deputies, how far up the chain of command does that go? Just the deputies, just sergeants now, maybe staff now?
I think that we addressed that in the report.
You're speaking a lot about this idea of this formal program being created. Setting that question aside, can you just talk a little bit about the practices that you observed and whether these were in violation of Messiah or other laws? And did you also look into the question of the disclosure of evidence in the courts related
And we talk about the fact that there were discovery violations, and some of those are mentioned specifically within the report that we did find, especially towards the end, dealing with the Anaheim Police Department and the two mercenary informants that were in the Anaheim jails. That was widely reported for a while.
The appellate court in November painted a picture of repeated constitutional violations of targeted defendants' rights. They claimed it was intentionally or negligently ignoring of violations by the DA's office towards the Sheriff's Department. Are you saying that the appellate court got that wrong?
I'm saying the appellate court made a decision based on the evidence that was presented to it from the trial court, which is completely within their job to do what they saw. They called it the way they saw it.
Completely different. The
Right.
picture you're painting is there was no widespread violations. There's no targeting of informants. So you're saying that the picture painted in that appellate decision was false in essence.
The grand jury's job is to look at the operations of government offices. We looked at the operations of the district attorney's office and the operations of the sheriff's department office within the context of their use and practice of jailhouse informants. It's not our job to retry cases. It's not our job to weigh in on what the courts find or don't
You
find.
reached a
But
conclusion that's very
yes, we did.
very-
Based on all the research that we did, that's what we've concluded.
How many inmates did you find had their constitutional rights violated?
Again, the Orange County Grand Jury was not looking at specific civil rights violations. That's outside our jurisdiction.
But you said you looked at discovery.
We looked at previous cases to determine whether or not we could determine a systematic or systemic violation of rights that went directly to the operations in the DA's office. Does the DA have operations wherein they routinely do these things? And we did not find that to be the case.
You found violations of constitutional rights in certain cases.
We found discovery violations in some cases, yes.
How many deputies were implicated?
How many, I don't know that we address specific individuals. Again, we're looking at the operations of the departments and how those departments go about their day-to-day business and whether or not it is efficient, legal.
Or when you said there were road deputies, do you have any sense of how large that group was and how many road deputies were quite relevant to whether or not this is a problem or just
I'm going to stick with it was a handful of rogue deputies. Yes, ma'am.
When you were discussing the systematic, whatever way you define systematic,
Mhm.
you were talking about an official government program with
Yes.
okay. If that had existed, as I understand the issue, that kind of a program is not the issue, because that would have been illegal if they were violating people's rights. But this was kind of an undercover program that went on for years.
I think there's a mistake in assuming that all informant use is illegal. And the report talks about there's a lot of legal uses of informants, and the Supreme Court has upheld the use of jailhouse informants. And there's something called a Perkins operation that is legal, and it's been held up in case law, and the report deals with that as well. So I think the distinction between legal and illegal use has been blurred to an extent.
Yeah, well, that's what I'm talking about. So by drawing a line and saying there was no program, you're talking only about the basically legal use of informants, because to fit your criteria.
We did not find an illegal program either.
Okay. Then what about the 6 cases, the 6 unrelated crime cases, where the, murder cases and others?
Yes.
Where they either had to have trials or they left out? What about those?
I believe those have been addressed. They're addressed briefly in the report, and there were discovery violations that were found in those cases, and they're being looked at again for discovery violations. Again, that doesn't constitute a program.
Now,
We didn't find the existence of one before.
In the decry proceedings, we've seen a memo from top-level sheriff officials dated in 2007, in which they described one of the duties of the OAC Special Handling Unit as cultivating and managing informants, and it says that this ability is recognized by the district attorney's office. Have you seen that memo? And also, could that memo, do you think it's an example of maybe people misunderstanding what's illegal and what's not with an informant? Do you see the realities in what the memo says?
I think the definition of the word informant, which I know has come up in the Durkheim case as well, and we spend some time in the report delineating what we mean by informant. There are co-defendants and precipient witnesses that have been labeled informants that, for most people, that's not an informant. There are sources of information. I know that's one point of contention. Individuals who are recruited in the jail to tell jail deputies about jail politics and jail safety, whether somebody has pruno or somebody's put a hit on somebody or there's going to be a fight in the mess hall. Those aren't considered informants as far as we can tell, and that's not what the problem, that there's something illegal with using that sort of information that's very valuable and necessary to running the jails. There are jailhouse informants who run around the jail and gather information. Information is currency in the jail. And so they will gather information to try and sell it to the deputies for favors, either extra phone calls or housing changes or reductions in sentence. Generally, those people approach the jail. The deputies aren't out recruiting them. If they come with information that is valuable, and the report deals with this, they come with information that's valuable, they will pass it on to the local law enforcement agency to investigate if there is a relationship. Generally, it's with the local law enforcement agency and the informant, not with the sheriff deputies who are simply facilitating connections. And then there are those mercenary informants that have been widely reported to exist, but at the end of the day, there's very few, and they had very targeted cases that they were working. One of the issues here in Orange County was Operation Black Flag and Operation Storm and Aces, where we had Fernando Perez and Oscar Moriel in the jails. And they were there specifically to break up and bring down the Mexican mafia. And they had contracts with the federal government for informing. That was run by a federal task force with a federal U.S. attorney who ran that task force in the Orange County jails. And a lot of what's been reported about informants comes directly from those cases.
Is it your belief that people in the jail can be managing and coordinating informants?
I don't know that we address what they can or cannot do per se, other than what we found.
Given that you're not a criminal grand jury, you're civil.
Right.
Is there a law or regulation that bans you from sharing your findings, your interviews with the public?
There is, actually. Penal code, the only voice the grand jury has is the report that comes out. So, of course, and there's 19 people on the stage, you can imagine there's probably 19 opinions of things, but that's not what happens. It comes out as a single unit.
The report unanimous on every section.
I am prohibited by penal code from telling you what any final vote was on anything the grand jury does. I will tell you it's overwhelming.
Did all members of the grand jury review all of the testimony, or did you have like a special committee that handled those, or?
This grand jury is exceptional. There are 17 people on the stage with college degrees. There are 3 PhDs, 2 JDs, a CPA, 5 MBAs. And everybody on this stage participated in this investigation completely.
But you didn't have a special committee?
We did have a committee.
How many members were on that?
There were 7 members on that committee.
Can you give us the names?
No, I cannot. Again, the committee works on behalf of the grand jury. It doesn't work separate, or it's in kind of a separate entity. It's a member of the whole. The lady in purple's been waiting.
I'm going to butcher this a little bit, but please go over once again. You had said something to the effect of have the supervisors, and I believe you were speaking about the district attorney's office, had supervisors in the DA's office done a better job of monitoring, and then I missed the next few things, but basically the episode could have been avoided. Can you go over that once again? And are you making recommendations to the DA's office, and if so, what are they, and what should the supervisors have done, and what could have been avoided?
The report has, how many findings did we have? We have 10 recommendations. And I'm flipping through the findings. And we had 13 findings. And if you like, I can read those to you guys. Do you want to hear the findings? Okay. Finding 1 would be on the other page. The myriad definitions and nuances of what constitutes an informant have caused confusion and may have contributed to the current controversy and unnecessary erosion of trust. Finding 2, there is no structured jailhouse informant program operating in the Orange County jails. The existence of informants in the Orange County jails does not constitute a program. The use of an in-custody informant is generally organic in nature and narrowly focused. Finding 3, violations in discovery and/or Brady disclosure in the Decry case are limited to the actions of a few members of the District Attorney's Office and a few Orange County Sheriff Department personnel. This does not represent a conspiracy between the Sheriff Department and the DA. Finding 4, the Orange County Informant Index is an incomplete repository of informant information and history due to the voluntary discretion of local law enforcement agencies to contribute to it. Finding 5, local law enforcement agencies are and continue to be a weak link on the prosecution team. While Orange County District Attorney has no authority over these agencies, they can certainly use the bully pulpit to raise awareness of the problem and encourage participation and commitment to proper legal standards. Finding 6, the elevation of personnel in the Orange County DA to supervisory positions is not the result of standardized objective hiring standards and does not include any required training in management and supervisorial skills. Finding 7, the Orange County DA needs to continue and expand the existing training programs to include objective standards in place to evaluate the actual effectiveness of OCDA training. Doubts continue as to whether training in its current format will make substantial differences without metrics to measure impact. Finding 8, interoffice communication within the OCDA is often lacking and contributes to the absence of a unifying vision or sense of leadership. This allows for individual prosecutors to drift and create individualized record-keeping systems that could pose a liability for the county. It is an untenable position to argue that poor communication within the OCDA is the culprit to explain away constitutional discovery and Brady obligations. Finding 9, hiring an independent monitor to oversee work recommended by the IPPEC and already completed by the OCDA is a waste of county money. Finding 10, mistakes were made by personnel in the Orange County Sheriff Department and the Orange County DA. In response to internal investigations, the Sheriff Department has taken disciplinary action to the extent it is able to do so at this time. There appears to have been minimal consequences for personnel in the Orange County District Attorney's Office. Finding 11, both the Orange County Sheriff Department and the Orange County DA need updated technology and record-keeping systems. Finding 12, in spite of no official completed investigations, the Orange County Sheriff Department has proactively made structural and organizational changes to address the issues that arose as a result of the informant controversy. And finding 13, the current promotion process in the Orange County Sheriff Department that requires patrol officers to be reassigned to the jail contributes to a culture of inadequate supervision of long-term jail personnel. Recommendations in a grand jury report have to flow directly from the findings, of which we had 8. Recommendation number 1, the Orange County District Attorney should prioritize updating the current case management system to better track all constitutional and statutory requirements and better interface with local law enforcement agencies and the Orange County Informant Index. Give me Kleenex. Recommendation 2, the Orange County DA should continue working to improve and prioritize its training program by designing and implementing follow-up measurements to determine the effectiveness and impact of current training content and methods. Recommendation 3, the Orange County DA should implement standardized management hiring and training practices for all supervisory personnel and review employee disciplinary practices to ensure they are sufficient responses to employee actions. Recommendation 4, the Orange County DA needs to send a clear message to local law enforcement agencies that successful case prosecution relies on the sharing of information, and agencies should be encouraged to share all informant information with the OCDA for input into the OCII. Excuse me. Recommendation 5, prosecutors within the OCDA need to recognize that the OCII is a tool of limited utility and should not rely solely on the Orange County Informant Index to vet potential witnesses. They should continue to do their due diligence and background checks of all witnesses in their prosecutions. Recommendation 6, the Orange County District Attorney should standardize its discovery record-keeping system for recording and tracking discovery materials and ensure all prosecutors are aware of and use the new uniform system. Recommendation 7, the Orange County DA should review their management and communication to improve interoffice communications and break down the negative effect of siloed operations. Recommendation 8, the Board of Supervisors should review and consider canceling within the next 90 days the Orange County DA independent monitor contract implemented on recommendations from the IPEC and approved by the Board in August of 2016. Recommendation 9, there's 10. The Orange County Sheriff Department should standardize and consolidate jail activity records that have potential discovery repercussions and minimize multiple filing systems for recording potentially discoverable material within the jail management system. And recommendation 10, the Orange County Sheriff Department should improve supervisor training for newly promoted sergeants that includes demonstrated supervisory skills before rotation back to the field. Yes, sir.
Judge Goethals has alleged that there was perjury by sheriff's deputies to hide the TRED system or to not disclose the TRED system in sworn testimony. Did you review that, and what did you think about that testimony?
It is not the job of the grand jury to investigate individual cases of potential criminal activity.
The grand jury find anything that might merit disciplinary action by the state of California?
That would be something probably outside of our jurisdiction. Again, we're looking at the operations of county government, its efficiency, its use of money, its impact of policies.
There was, one of the findings was that the issues were limited to a few members of the person doing it, so I'm just curious if that those few members will be facing any action or found that the president was.
You'd have to ask the district attorney.
Did you find any case where an informant was intentionally placed in a cell next to a target?
I'm trying to think how to answer your question in the context of the report. Again, the use of informants is not illegal. Local law enforcement agencies and the sheriff's deputies do use informants in the jail. Mercenary informants have been used.
Case where an informant was intentionally placed next to a target illegally
Illegally?
or in violation of discovery rules or procedures.
Again, that would be outside the jurisdiction of the grand jury. We did investigate the Perkins operations that occurred in Anaheim PD, and the report talks about those.
Well, I thought that's the large scope of the investigation, wasn't finding out if informants were intentionally being placed next to targets.
The scope was to determine what the current use and previous practices were for the use of jailhouse informants. Do they use them? Yes. As far as we know, they use them legally. Have they used them illegally? That's up for the courts to decide. Again, we looked at the law surrounding the use of them, the current practices and policies that the DA and the Sheriff Department have for using informants, and we looked at what has been done in the past, going through the special handling log and interviews to determine what had been done previously.
How is placing microphones in the cell of Scott DeFry and then enlisting Fernando Perez to talk with him not a Messiah violation?
It gets into the nuances of law regarding Perkins operations, and there's something called a listening post in a Perkins operation. When you are in jail, you do not have any expectation of privacy. Messiah protects the law enforcement from either them or from placing an agent with you to elicit information about the crime for which you are.
In a Perkins operation, you know there's a huge difference, right?
Yeah.
Tell us what it is. 'Cause it doesn't seem like you understand it right there, what you just said. What's the difference between a Perkins operation and a Messiah violation?
A Perkins operation is an operation that you run. A Messiah violation is a violation of your constitutional rights.
Who's the target in a Perkins operation?
Usually an inmate.
A person who hasn't been charged and doesn't have a lawyer. Who's the target in a
Having a lawyer, if I arrest you for drunk driving and you have a lawyer for that case,
You've been charged.
and you're charged with drunk driving, I can put an informant in a cell to ask you about a murder I think you had something to do with 6 years ago. And
Ask you about a conviction, about a DUI.
you're asking me about when a Messiah violation is triggered. And it's only for what the case for which you are charged.
Scott DeCry was charged.
Yes, he was.
without a lawyer.
Yes, he was.
The question was a microphone and informant placed there.
Yes.
Is that a Messiah violation?
It is not a Messiah violation as long as the informant is not trying to elicit information about the crime for which Scott DeCry was charged.
The logs,
Have you read the case law?
Yes, what was the, I understand perfectly. What was the different crime
Yeah.
that DeFry was being asked about?
And again, we're not investigating the legality of the DeCry case per se. We're looking at the use of informants in the Orange County Jail, when it's legal and illegal, and what the current practices are within the DA and the Sheriff's Department operations.
Among some of the other allegations throughout this litigation, it talks about placing people in disciplinary isolation next to certain targets who haven't done anything to be put into disciplinary isolation, calls it a decisive scam. Did you guys address that, and what was the conclusion on whether, how kosher that was?
Orange County Sheriff deputies have the right to move inmates within the jail as they see fit for the safety of the facility and the inmates that are there. The placement of individual inmates is not something the grand jury investigated. So if they place somebody in isolation, it's up to the jail to decide where that person goes.
Right, I mean, you find that it's obviously, you're saying moving informants around the jail to perhaps get information that might be helpful in cases is legal, but I'm not sure if I understood what you were saying there. The specific allegation of placing them in disciplinary isolation to elicit
Again, we don't, if it's a practice of the sheriff's deputies to move people within the jail the way they see fit, that's their job. Whether they put them in isolation, protective custody,
Practices of the sheriff's department.
we did.
But you didn't look at that section.
Within what context?
You're the one that created this investigation. You tell me the context of.
I think I already have.
Pushing aside.
I just don't think you like it, but I think I have.
Okay, and not to beat a dead horse, but coming back on the crimes, I know what a listening post is, but is a listening post supposed to ask questions?
No.
Which Perez does on
And I believe that when Wagner said that he conceded to the Messiah violation, he believed that Goethals was going to find that's exactly what happened. And I believe he's on record as saying that.
Do you find on your investigation any particular incident related to immigrants who haven't been deported to Mexico or somewhere else?
We did not investigate the role of immigrants or their experience in the jails. My name? It's Carrie, C-A-R-R-I-E, last name Carmody, C-A-R-M-O-D-Y, prefix is doctor.
I was wondering if you could speak to the expertise of the grand jurors, background in investigating, law enforcement, other background that helped investigate.
We have 2 JDs who are familiar with the law. We have people who have served in law enforcement. We have a career law enforcement officer. I have been involved in research for many years, as have several of my colleagues.
Can you say which agencies the people served in?
No, I cannot.
Can you say if they were the DA or sheriff?
Nobody here worked for the DA or the Sheriff's Department,
Did they work with the DA or sheriff's department?
not to my knowledge.
Did you have anybody from the defense side of the, any experience either in defense law or?
It's a lot. Like I said, we talked to all angles of the people involved in this, both on the grand jury. You're asking if I had any defense lawyers on the grand jury? We have a lot of legal counsel that we received from both sides of the bar.
But you don't have any members of, you've got prosecutors and law enforcement, but no,
I don't have prosecutors on this jury. I have lawyers. I don't have prosecutors.
what kind of lawyers?
You know, the kind that practice law.
What kind of lawyers?
I don't know that that's relative or relevant.
Yeah, it's very relevant, okay, civil or criminal?
Again, the individuals on the stage represent the Orange County grand jury. They represent the power and the gravitas that comes from the grand jury. They go through a 6-month vetting process with all the judges in Superior Court, background checks on every single person here, extensive fingerprinting and things that happen before they're chosen to appear on the stage. So the Superior Court of California believes that these 19 individuals represent the county and have the skills and ability that they need to fulfill the duties of a grand jury.
Yeah, but one of the criticisms of grand juries is that their reports can
Yes.
fluctuate, is the substance that they get into, not the hours they spend or any of that, but the actual substance of the work that they provide. So, knowing what kind of expertise is built into a grand jury and what expertise is lacking, can be really important to the public.
And like I said, this grand jury is exceptional. There's quite a bit of research and expertise, and the areas that the grand jury does not have personal experience in, we seek it from outside counsel.
So, to clarify, I'm with the law journal, you're not gonna say what the legal background is of the members, or
That is correct.
you're not gonna tell us?
That is correct.
And you're
It's not pertinent.
And you're a doctor of what?
I'm a doctor of psychology and social behavior. I study identity.
Talk a little bit about how the process worked, how many times you guys met,
The grand jury meets every day, Monday through Friday. We put in 25 hours in the court and in our panel room, and then many of us spend another 25 hours on our own time, weekends and evenings. I think we talked about, we interviewed over 150 people within this investigation, and for those of you who follow the grand jury, this will be the 8th report that we have put out this year. Pardon? How long do we meet every day? We meet from 9 to 2:30, Monday through Friday. The grand jury serves for 1 year. So we were impaneled on July 1st, well, July 3rd, 5th, because of the holiday. And then our service ends June 30th,
When did you start this investigation?
July 5th.
You discussed a lot about the erosion of public trust that came out of this. Are you concerned at all that there may be negative implications in regards to public trust in the grand jury if the Attorney General comes back and finds that there was indeed a jailhouse informant program?
The grand jury feels that it did a very comprehensive and thorough investigation. The other investigations have a different focus, and they'll find what they find. Like I said, we haven't talked to them, they haven't talked to us. I don't know the direction of their investigations, and I don't think they know what ours was either. So, again, the grand jury stands behind this report. That's what we found, that's what we discovered with all the work that we did. Are we done? One more.
Yeah, thank you. Is it that we're getting hung up on word games?
Yes.
Source of information, informant, isn't it? I mean, you're saying that they're different things, but to most people, aren't they the same thing?
As a scientist, operationalization is the first thing that we do. Defining the terms of which you're going to speak is incredibly important. Words matter. And I think we state this in the report. Had we all been very clear on what we meant when we said the word informant, a lot of this confusion may have been avoided.
The penal code says the grand jury may inquire into all public offenses committed or triable within the county and present them to the court by indictment, and that any member of the grand jury can initiate that investigation. As both a civil and criminal grand jury, did you consider any kind of review as to whether there were any crimes violated or?
The criminal portion of the grand jury is involved with the district attorney bringing indictment hearings to us. We do not generate indictment hearings.
The penal code does not seem to require that the DA bring the case. That says that any
The grand jury cannot go bring you in and put you under indictment because we don't like you. That's not the way it works. The only way the criminal job of the grand jury is limited to criminal indictment hearings being brought to us, and we sit and listen to those hearings. It is true that if we believed a public official, elected official, had done something that rose the level of malfeasance, nonfeasance, or misfeasance, we could ask for an investigation to be done, and that normally we would ask the district attorney. In this case, if we had found that, we would have asked the attorney general.
And that was my question, what are your powers, like, as a state officer,
I think if you go, you can look on our website, it tells you what the penal codes are. But I think that's it for today, guys.
Did you review whether you were going to ask for any investigation into potential criminal matters?
Everything we have to say is in the report. Okay, thank you all for coming.